Welcome to Under the Microscope. I am your host, Jenny Germano. Thank you, everyone, for joining us. Today's topic is high stakes, cannabis, firearms, and federal law. This is going to be a really fun topic to dive into today. Let me go ahead and give a little bit about my background before I dive in. I got my start working in the cannabis industry in 2009 here in Denver, Colorado, running vertically integrated cannabis operations. And in 2015, I founded my company, ICS Consulting, and I help cannabis operators navigate the regulatory challenges and landscape across the United States. I would like to introduce our next guest. This is Rachel's second appearance on my podcast, so she's no stranger to being on Under the Microscope. So let's everyone give a warm welcome to Rachael Ardanuy. And Rachael is the founder and attorney at RZA Legal. Welcome, Rachael.
Thanks, Jenny. I'm so happy to be back with you.
I think you were my first guest, or it was podcast number 2 that we did an episode on how to set up your business documents and get your business set up to get going in the cannabis industry. So I'm so happy to have you back. This is a really fun topic. This was your idea for a topic, and I was very excited when you mentioned it, and I was all 100% for it. We're diving into an issue that sits at the intersection of cannabis law, constitutional rights, and real world risk. And it's one that many people don't even realize that exists. Cannabis is legal in Colorado and other states across the country. You can walk into a dispensary and make a purchase without a second thought. But under federal law, that same action could impact your ability to own a firearm. With a major case heading to the U.S. Supreme Court, this issue is evolving quickly, and the implications for cannabis consumers, business owners, and operators are quite significant. If you could walk us through what federal law actually says about cannabis use and gun ownership to get us going here.
Yeah. Thanks again for having me here again. I'm Rachael Ardanuy. I've been working with cannabis businesses for about 10 or 11 years now in Colorado, and I'm licensed in Colorado, Florida, and New Jersey. One thing we learned about back in law school is constitutional law and what our constitutional rights are. And so a little background information on that is the Second Amendment is that part of our Constitution that gives the right to bear arms. That right has evolved over the past 250 years since we've been a country, and it has become really involved when it comes to cannabis. You're totally right. We're still in this weird space between states that have legalized cannabis for medical or adult use and the federal government, which has not moved cannabis off of the Controlled Substances Act since it was placed there in 1970. And while this impacts taxes, it impacts the right to file bankruptcy, it impacts immigration issues, impacts so many things because of that disconnect between state and federal law. And so currently, things have changed over the past couple of years. Previously, the government would look at a restriction on your Second Amendment rights and decide, is this something that is necessary in order to forward a governmental interest? So safety, not wanting to have people who are mentally ill or habitual drunkards. That term comes up a lot in the case law. But people who one would think we don't necessarily think that it would be safe or it would further the rights of why you should be able to possess a firearm and whether that's something that is necessary. And so in 2022, there was a case called Bruen. And in Bruen, before, again, the courts used interest balancing tests and the restriction on having a gun were often upheld. But now at Bruen, the government has to show that the regulation in place aligns with historic firearm traditions. That's kind of a weird test. It's basically saying, what were the founders thinking? And how would they have limited firearms? What was the tradition back then? And is the current restriction aligned with that? And so it shifts the focus from the policy rationale to what historically did they do and how is that closely related to what the restriction is here. So currently on the form that you have to fill out in order to buy a firearm, it's a form that's put out by the Department of Justice, ATF, and on it asks the following question: are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? Warning: the use or possession of marijuana remains unlawful under federal law, regardless of whether it's been legalized or decriminalized for medical or recreational purposes in the state where you reside. So obviously the feds have been tracking what's been going on. They understand that there is mass confusion related to this. We know as Americans that the right to the Second Amendment, the right to bear arms, is pretty unfettered with certain regulations, right? Most sensitive locations, you can't bring a gun in schools or hospitals or government buildings, things like that. But other than that, you're allowed to have a gun for the most part. You're over 18, with the exception of a lot of other questions here, right? They ask a few other questions. But one thing to note is that if you check the box, no, I'm not unlawfully using marijuana, which guess what? You are. Everywhere in the country, you are.
Crazy. It's
right.
So
and
crazy.
It's not fair, right? Because and this really just highlights, we have a very unique system of government. The states have their own areas of law that they get to make laws and rules on. And the states have said clearly in the majority of states that we don't think marijuana is something that should be illegal, that this is not something that we are concerned about, or that we think it should be regulated, but we don't think people should be going to prison for this plan. It specifically talks about certain types of drugs, and then it says, or any other controlled substance. Are you addicted to it? That's a question that remains to be seen. Are you an unlawful user of it? That's the question. But then that warning goes on to talk about possession. And so a lot of times we run into these cases where it's police come, search your home, find guns, also find weed. You get charged for violation of this federal statute that says you're not allowed to have a gun if you are an unlawful user or addicted to marijuana. So what has happened is Bruen said, listen, if the facts of your case are aligned with how the framers back when we first started the country would have done this, that's going to help us decide this decision. And so that happened in 2012 with Bruen, okay? And so since then, we've had a few other cases around the country that have, where defendants who were arrested with a gun, with marijuana in some fact pattern, is fighting their charges and saying, no, this is unconstitutional. The fact that you're limiting whether I can have a gun based on my marijuana use or my marijuana possession or whatever. Okay. And so it really has become a case by case basis of specifically the facts regarding that case. And some of the cases have further changed and shifted what that rule looks like. It's still this historic analog case, that's still the standard. But other cases have said we need to look at what's called temporal nexus, which is how closely in time is the marijuana possession and the gun possession, and does that impact whether we think that this person should be restricted? And so that kind of goes to that habitual drunkard thing. People were drinking all the time back with the founders it was probably safer to be drinking beer than other things at that time. And so there was a lot of drinking going on there. The question was, and they would look at this backbone too, is, are you a habitual drunkard? Are you always drunk? Are you drunk and shooting your gun off in the streets? Or are you drinking on Friday and then going shooting on Saturday or Sunday? You know what I mean? So then states started looking, we need to look at, are they sober at the time? Because that's what we're concerned about, right? We're concerned about dangerousness, individualized dangerousness. And so that's where they want to look at more facts of what else are they doing? What other facts are going on in this case? And is it really just the marijuana and the gun, or is there a lot more going into it here? So that's the key theme that sort of emerged, was like dangerousness versus status-based disarmament, right? You're a marijuana user, that's your status, we're taking your gun away, versus because of your marijuana use, you are a dangerous person, and as a result, then we're taking it away. But that requires, again, like a really thorough analysis of the facts, because maybe you're a person who uses marijuana, but it wouldn't be dangerous for you at the moment in which you had the gun or when you were caught. So that's where these cases have gone up until this Hemani case.
Which has been the shift with cannabis and guns compared to how it used to be.
Yeah, I think things are loosening up now, partly because reefer madness is slowly dissipating, very slowly. But I think because the courts are not just painting people with a wide brush anymore. Oh, you're a marijuana user. That's something that we would have historically kept a gun away from, which is not actually true. So Hemani actually was just heard at the Supreme Court. They did oral arguments in March. We don't have an answer yet, though. So it's on their desks now. They're deciding this now. So now's a really great time to be running this podcast, right? Because we're not going to be wrong either way.
That's true, yes.
We just don't know what they're going to do. What was weird about this case is that usually in the other cases, it was the defendant who was appealing because the government kept saying, nope, you're guilty, you're guilty. In this case, he was dismissed. The charges against Hemani were dismissed. The government appealed, saying, no, we think you got it wrong.
Wow.
And then the Fifth Circuit Court of Appeals affirmed the dismissal, said, no, there's no case here. There wasn't a dangerousness finding. And then the Department of Justice again appealed it and got it to the Supreme. And the Supreme Court took that case. Now, a lot of people were disappointed. I don't want to say disappointed, but this was a weird case because it brought together gun proponents. It brought together cannabis proponents. They all found themselves arguing on the same side, which is sometimes those are different crowds.
Yeah,
we will
definitely,
say,
100%.
you know. But the NRA, even the National Rifle Association, they filed an amicus brief in this case, and they argued to the Supreme Court, hey, marijuana users are not historically a class that you would disarm, and laid out a bunch of information there. 16 different organizations filed briefs in this case that were not parties to the case, but they filed briefs, including NORML, that I'm a part of the legal committee. But a lot of organizations filed briefs in this case, many of which were saying, listen, this is not the guy that you need to be taking the gun away from, or based on just the fact that there was cannabis involved. Now, one thing that was tricky is that this person, the facts of this case is there was other drugs involved and some other activity involved. So what typical stoner sitting on the couch, happen to have your gun on you or whatever, driving in the car and you have weed and guns, and that was it. I think there was cocaine involved and a few other things. But even with that, it'll be very interesting to hear what the Supreme Court has to say.
Do we know when that's going to be at all? Any chance?
Don't know. It's within the next couple of months. But this matters because it can resolve some national uncertainty. They do have the opportunity with this case to make a bright line rule related to marijuana to say, listen, this is not, we're going to stick to the dangerousness. We're going to stick to the historical tradition. Or it could go the other way, right? Which would be pretty devastating. It could be a clarifying moment for the law, because right now, the law that I'm referring to is the Gun Control Act. And so we mentioned the form that asks those questions, but the reason it asks those questions is because the Gun Control Act, which is a federal law, bars any unlawful user or addicted to controlled substances from possessing firearms. So maybe there's a chance they could make the rule just for marijuana. There's a chance that they say, we're not going to make a rule on any sort of controlled substance, except that it's going to have to be proven that there's a dangerousness issue here.
I can't imagine anyone checks that box.
Yeah. Before Bruen, what was interesting, because I know we're going to get to talking about this a little later, but there was a case called Wilson v. Lynch, and that found that it didn't violate their Second Amendment right of a Nevada medical marijuana registry card to say, have marijuana, you're not allowed to have a gun because of marijuana. So that was the pre-Bruen case. And then the Bruen case happened, and the court said, you know what? We're not going to say that just this. It's not going to be like a balancing test anymore. It's going to say the government has to show the gun regulations are consistent with the nation's historical tradition of firearm regulation. So again, it's a weird thing. It's like, how often do we go back in time 200 years to say, what did they do then? And this has to be like that. And some of those other cases said, like, it has to be like that. A lawful user, they did define. So there was a case in 2024 called U.S. v. Connolly. And that was about, in that case, the court rejected historic analogs. The government said, we have a history of disarming mentally ill, disarming dangerous people, and intoxication laws. And so they held that it was unconstitutional applied to this defendant because they were sober. They were not under the influence at the time. There was no evidence of intoxication. And they basically also in that case defined what a lawful user is. Unlawful users used regularly in some temporal proximity to the possession. So they did limit, like, okay, we're not going to say if you have marijuana, you're a marijuana user. Totally, that's going to be a complete bar to owning it. But now you have to look at, were you high? Were you intoxicated on possessing the firearm? Which, hey, we have those limitations related to alcohol. It does make sense for a dangerousness perspective. So that's like where we were going and where we are now. And just to give you a few like details of Hemani, because a lot of times we don't know what the facts are. And because this does boil down to what the facts are now, with Hemani, FBI agents executed a search warrant at his home in Texas, and they discovered a pistol, about 60 grams of marijuana, 4.7 grams of cocaine. And so based on them literally just executing a search warrant in the dude's house, they indicted him for violating that firearms law. And so he filed a motion dismissing, saying, nope, it's a violation of my Second Amendment rights. And the government actually did not object in that case. And so the court dismissed it. But then the government appealed it. And then again, that was affirmed. The dismissal was affirmed. So yeah, it really was interesting. And just to know what the facts are of going on. But they really do talk about in that case, adding that habitual drug users present particular risks, especially the danger of armed impaired encounters with law enforcement. You can see how the government would argue that. But habitual marijuana user is very different than a habitual fill in the blank meth user or something, right? Some other sort of drug. And that's the hard part of us lumping in marijuana with other types of intoxication, because we know that there are varying levels of intoxication. So that's been interesting. And in the interim, which was also pretty interesting, and I think this goes against the government's argument, was ATF published a new proposed rule in February that said, oh, hey, we're talking about clarifying that form that I read to you earlier. And it wants to add a new provision to clarify that a person is not considered an unlawful user if they don't regularly use the substance, or if they use the substance in an isolated or sporadic manner, or if you've only smoked one time. So if you smoked one time, you got caught smoking, you have a gun, we're not going to count that. But 2 times, yes. All is very arbitrary, right? But the fact that the same government that's arguing against this guy is also saying, we're going to loosen up our own form, I think is pretty telling.
Interesting.
The court's going to see that and say, okay, they acknowledge that someone just possessing cannabis or being a general user, like, what does that mean? So I think we're moving in the right direction here. And it'll be really interesting to see how that pans out.
You really dug into it for us, because I'm definitely unfamiliar with cannabis and guns. And I have some questions a little bit later around operators. I get asked these questions all the time, and I'm sure you do. I kind of want to talk a little bit about individuals. And if someone uses cannabis legally and wants to purchase a firearm, we just went over what they need to understand. We talked about the form. What about medical marijuana patients in a different position at all? Are they protected more because they are patients versus a recreational user?
Not really. In Colorado, it's a state constitutional right, whether it's adult use or medical. So there's no added protections if you have a marijuana card. In Colorado, the laws are pretty clear on when law enforcement can look at the medical marijuana registry. And where I'm going with this is the other direction. Can I get in trouble quicker if I'm a medical patient? Because you hear that too, right? People are like, well, I don't want to be on a list in case they find me with my gun.
I hear that so much.
And so the laws are actually pretty clear in Colorado that law enforcement only has the ability to access the medical marijuana registry to confirm that you are a medical marijuana patient related to possessing marijuana. So it's not something that they can do to try to help you lose your job or further charge you with other crimes. So there isn't a risk. It is confidential, except under certain circumstances of whether or not you are on the registry. So I hear that a lot too. People are like, oh, the risk of being on the registry.
Yeah, I agree.
There really aren't. Now, if you have a security clearance of some kind that with the federal government that prohibits you from being a marijuana, could that hurt you like from your job perspective, yeah, for sure. You shouldn't be consuming it if you want to keep that job and the job doesn't allow you to do it. And I will take this opportunity to say in Colorado, as much as we have a lot of protections for cannabis users, we really do not when it comes to employment. So you can absolutely be fired from a job for consuming marijuana, even if you are a medical patient. You and I Jenny and I have done some lobbying in the past and things like that and staying politically active as it relates to marijuana activism in Colorado and across the country. And that is a huge gap here in Colorado. I know we have listeners from all over the world here, but in Colorado specifically, there are no legal protections for people from losing their job.
Do you remember the Comcast case in Colorado?
That's
automatically
close, not
thinking of
Comcast.
Was it Comcast?
Dish Network.
Oh, sorry. It was
Yes.
something like that happened in Colorado as an employee.
Yes.
So you know all about that case.
That's still the law. Unfortunately, that's still the law. And so listen, the Supreme Court of the state, the Supreme Court of the country, they can make laws all they want or interpret laws and create new rights or take away rights. But the legislature could always override that. So here in Colorado, the Colorado Supreme Court decided the Dish Network v. Coates case. And that was the case. They basically, listen, we know it's legal here, but it's not legal federally. And we protect people from off-duty legal activities, but we don't count smoking or consuming marijuana as lawful off-duty because of the federal illegality. So yet another issue of if the federal law, if it was no longer federally illegal, would you be protected under state law? And arguably you could say at that point, yes, this needs to be revisited because it's not illegal anymore. It's not unlawful off-duty activity. It's lawful. But unfortunately, that's where we're at when it comes to the right to have a job. Now, are there plenty of employers in the state of Colorado that don't consider that? Sure. Most of it's in the industry. I know we'll get to the industry too. But if a dispensary or a grow facility, if they're not drug testing you, if they don't have a drug-free workplace, they can't fire you for consuming cannabis off duty. Now, can they fire you for being intoxicated at work? Definitely. And we've definitely seen that happen, and that's lawful. When it comes to going back to your point about the real world decision making and practical stuff for individuals, don't lie on that form. But if you check, yes, I am an unlawful user of marijuana, you're not going to get the gun.
Yeah.
But if you check the box, no, and it's not true, then that's opening you up to a felony on the form. It's very tricky. But that said, because of the way that things have changed, consider what the courts look at. Consider the temporal nexus. Consider also what this new ATF rule is, which I don't have. Let me see if I can pull anything up while we're on the pod. But as far as that proposed rule, actually, it's still proposed. I'm going to send a link so that way your listeners can weigh in, because this rule that changes what an unlawful user of addicted or controlled substance is for this law and for this form is still subject to public comment. And it's still open. Yeah, it's still open for public comment and for another 83 days. Well,
I'll put that link in the description box.
Yeah, that would be
YouTube
amazing.
channel.
And I think people should, if you care about your right to carry a firearm and also your right to be a responsible marijuana user, then I think it's important that the government hear from you, because that's how these things go. If they don't hear from you, they're going to hear from those who think the opposite.
It's the same in the cannabis industry. We have work groups, you have public comment, you have rules and regulations that go into draft language. And as a cannabis stakeholder, anyone can come in and make a public comment on how they feel about that rule or regulation before it becomes a permanent rule in cannabis regulation and what you're talking about. That's really helpful. And that's so funny. I remembered the Dish Network case. That was a really big deal. And it made me think about back when I used to work in the restaurant industry. I actually had been drug tested several times. I worked 23 years in hospitality and restaurant. Certain hotels that I worked for, we actually had random drug testing, and they had a drug policy, and that included cocaine, marijuana, all these things. And so obviously don't work in the restaurant industry anymore. Maybe it's evolved, but for my days in working in restaurants and commercial kitchens, everybody did drugs, cocaine, marijuana, drank tons of alcohol. And I don't think it's changed, but maybe it has. I also wanted to hammer down on that piece about the cannabis medical patients, because when I was working on the medical side in dispensaries, and then we were about to go to adult use in Colorado, a lot of the patients were saying, I'm going to pull myself off the registry and I'm just going to shop on the adult use side because I don't want to be on the registry list. And a lot of their reasons were because they owned guns and they wanted to get off that list. They wanted to get off the registry, or they didn't want their job to find out if they were, maybe they worked at a hospital, they're a doctor, a lawyer, though I don't know many lawyers that hide from cannabis use. So I know a lot of attorneys that smoke cannabis. So I find that interesting that patients think they have to get off that list and go to the adult use side because they're worried about being a patient and owning a gun.
I think that's a mistrust of government and a side effect of being stigmatized and being scapegoated for so long. But in Colorado, really, that's not the purpose of the registry. And I know no one ever wants it in the government, trust me. But no, there really are limits on what they can do with that list.
Is every state different for medical patients then?
If you're a medical patient and you're interested and you're concerned about this, I think there are ways to find out on what it means to be on the registry and what those limitations are. Here in Colorado, I believe it's found in statute. I'd have to check. I don't think it's in the Constitution, but I believe it's in statute that says these are the only reasons that law enforcement can consult the registry. And there's a reason why law enforcement isn't the one who keeps track of that list. In Colorado, 𝗘𝗽𝗶𝘀cie, which is not Department of Revenue, right? Department of Revenue, who manages MED and manages the business side of things, they don't even keep track of that registry. It's all under the Colorado Department of Public Health and Environment.
Yeah.
And so if we haven't learned anything from the past couple of years, it is that the government agencies don't necessarily communicate with one another.
Yeah.
One thing I did want to pull back out, because I do want to encourage everyone here to, anyone listening before end of June 2026, is to weigh in on that new rule. The way that it clarifies current use or evidence of recent use or pattern of use. Some examples they wanted to give would be like, were you convicted for use or possession within the past year? Were there multiple arrests for those offenses within the past 5 years if the most recent arrest occurred within the past year? Was there a drug test finding that they were using it unlawfully and provided the test within the past year? Or were you a current or former armed services member who received discipline or administrative action based on confirmed drug use? So these are just examples, though, of what they would be really looking for. I can't tell you, do whatever you want so long as you don't have a conviction and you can still check the box. No, but understand that would be the standard if they were to change the rule. For now, it's just very vague. So something to think about.
That's helpful. Like I said, I'll have that link so if people want to go and contribute, I think that would be awesome. I wanted to tackle cannabis operators and business risk. For license holders and business owners, does participation in the cannabis industry create any additional exposure when it comes to firearm ownership?
Potentially. And this, again, goes to who's arresting you or pulling you over, what law enforcement agencies are we talking about, and are they educated and up to speed on what these limitations are, as opposed to maintaining some sort of former stigma or bias against marijuana. And for example, are you allowed to have a gun at your dispensary? And you're going to hear, this isn't legal advice from me, but you would hear answers all across the spectrum from different attorneys.
Yeah.
And my take on it, from working with the cannabis industry for 11 years now, is that Marijuana Enforcement Division, the state regulators, do not mention firearms in their regulations. So there's no regulations related to firearms. There are regulations that require reporting requirements if certain crimes take place on facility property. So now that said, there's no date regulation that says if you're possessing cannabis that you can also possess a gun. There is a mechanism like in criminal law where if you are convicted of a certain crime and then firearms are involved, that could create an enhanced sentencing, like worse sentencing. Right. Felony or worse, longer jail, something like that. But again, that's in Colorado, local law enforcement, state law enforcement, they are only enforcing state laws. So they're not going to say, let's just say there's a licensed transporter with their badge on them. If they had their paperwork, their metric manifest, all of that, they have some deliveries in the back of the van, and they also have a firearm, is that going to cause concern? Just on those facts? Should not. No. Because they're not going to say, oh, you have marijuana here, and are you a user? And are you, again, I'm presuming that somebody is acting lawfully. They're not intoxicated while they're driving. They don't have private marijuana on them. They don't have open container. They're just literally just moving the cannabis pursuant to a manifest, doing
It's packaged and
packaged. Yeah, then you're not going to, that will not cause a problem having a firearm in the car. As long as, again, that was a lawful firearm and you are allowed to have it. Same thing with on a facility. Now, I've heard attorneys who are a little bit more conservative and concerned about that, and they have said, we think it's okay for you to have an armed guard, but that armed guard should be hired by an outside security agency and not be your direct employee. Is that going to be an even safer set of facts for you? Yes, for sure. But I have not encountered in my time of working with marijuana businesses across the state for the past 11 years where the fact that a firearm was on site caused any sort of problem,
Interesting.
legally speaking.
I find this so fascinating, honestly, because I get asked this almost every year by an operator. Can I have a gun on me? Attorneys have said it. Yes, no, or you can have a taser gun, or you can have this, but you can't have a gun, or you can have, like you said, the security guard, or telling operators you should probably get bonded and then you can have a gun. It's so crazy, all the different things that I've heard.
And part of that is because it's not clearly laid out. And again, like if we go back to what the current law is, it goes to unlawful user or addicted to. So that's not possession. So presuming people aren't using on site, which would be illegal and
Yeah.
against the regulation, if you're not smoking at the grow and the MIP in the store, if you're not unlawfully using, if you're not addicted to it, and they'd have to prove that, then there's no limitation.
Yeah.
Now, again, in Colorado has applied the rules, different restrictions to the Bruen test to different fact patterns in Colorado. And in most cases, all of those restrictions were upheld. And so I'll give you a few examples. There was a case in 2024 about unlawful possession of a weapon by a prior offender. And the court there relied on the historical tradition of disarming felons and dangerous people and people who pose a threat to public safety. And so that was upheld. If you're a felon, you may face limitations on holding a gun, whether or not you work in the industry or not, which the cannabis industry does allow felons to work in. Another case in 2025 that went to the Court of Appeals here in Colorado, firearm possession while being subject to a protection order. So this stuff comes up sometimes. I've run into situations where there's been maybe a disgruntled employee who's hassling a marijuana company, or just disagreements between employees or owners or whatever, where there was a concern for safety. And so a civil protection order was issued, which is a restraining order, if any of your listeners have heard of that. And yes, in Colorado, they aligned it with dangerousness regulations. And if there's a finding this person is dangerous, then that has been upheld. No, you can't have a gun and be subject to a protection order. As a restriction of bail or bond conditions, so you're out on bond and the court says, okay, you could be out on bond, but you're not allowed to possess a gun. That was upheld. Juvenile firearm restrictions, someone actually fought against that. Upheld. Second Amendment protections are focused on law-abiding adult. And so, yes, regulating youth participation in weapon access is something that has been historically done. Only 3 more cases. One involved restrictions on firearm possession in a government building. We talked about that as sensitive places doctrine. So that it is legal for the government to say you're not allowed to have a gun in certain places. Marijuana businesses are not sensitive places.
Oh, interesting.
So, yeah. But public safety, governmental function, those are the places we're talking about. Public housing authority with firearm restrictions. So if you are in public housing, that is something that they can restrict your right to have a gun. Basically, the court felt that those restrictions as a regulatory condition tied to tenancy It's something that has been historically done. So there, the government landlord retains the authority to impose safety-based firearm conditions. And then unlawful possession of a prior offender, same thing, upheld. Because if you're not going to be law-abiding, then you're outside law-abiding from a dangerousness perspective, then you're subject to regulation. The big takeaway is Americans enjoy a very wide freedom of possessing firearms.
Yeah.
Whether you agree with it or not. And so when it comes to disarming Americans, you and I are from the cannabis world. We're so used to people's rights to cannabis. And how does that impact things?
Yeah.
So it is a challenge to flip the script and be like, what does the government say about guns? And how does that intersection with cannabis limit that? And as far as the practical risks, like going back to what we talked about earlier, if you answer yes on that form, it's an immediate denial. You're not going to get the gun. If you answer no falsely, then you're subject to a potential felony.
Yeah.
So, but again, really digging into the definition of each and every one of those words.
I find it fascinating. Who determines whether or not they're addicted? Let's just say, we know sometimes when you get into trouble, let's just throw everything at them, right? Let's throw everything at them that we can. Oh, we have marijuana possession. We're just going to say they're addicted and they have a gun. We're going to look at their form and they didn't check the box and they have marijuana. And who determines the addiction? That's what's so crazy. How are they gauging whether they're addictive or not? And they lied on the form, because everyone could be lying on the form.
Yeah. Keep in mind, the feds have to be involved, right? So it's like FBI making these charges. It has to be federal charges. They're not state charges.
Not local, yeah.
You can certainly be charged under state law, like those cases I just talked about, where there are laws that say you're not allowed to have a gun in public housing, and then you do, and then the local district attorney can charge you for violating that law. But as it relates to just general possession under that federal law of there's possession, but there's also cannabis involved,
Yeah.
and so what's the answer? The feds have to prove all of that, right? You're
Yeah.
innocent until proven guilty. And so they would have to prove all of that. So there would have to be evidence. And that's why it really does come down to a fact-based analysis, case by case. And that's, I think, why also the federal government is also seeking to update that rule to say, these are the ways that you are considered addicted
Yeah.
to or whatever. And not to turn things political at all, but this is the same law that they charged Hunter Biden under.
Okay.
And what he went to court over, it wasn't related to cannabis. I think it was related to cocaine, maybe. But
Yes, I think he loved cocaine.
no comment. But it's this exact same law that they charged him with as well. And it still comes down to, is this someone who's insane? Is this a habitual drunkard? Is this someone that just swap out the fill in the blank drug and put marijuana? The analysis should be the same, right? Like,
Yeah.
are you
it's so
addicted?
fascinating.
Yeah, it really is.
I wanted to ask about a workplace policy. Should operators or cannabis businesses, should they have formal policies regarding firearms in the workplace? I feel like I see that in all the employee handbooks that I work on, that there's always some kind of violence policy, weapons and all that.
This is up to each individual business owner.
Yeah.
I think it does make sense to have those policies in place because you want to have a safe environment for everyone. But you and I know a dispensary in one part of the state versus a grow facility in another part of the state, there are different risk assessments to be done.
Yeah.
On the security, because that's the whole point, right? We don't want to have guns just for fun. We want to have guns for security purposes or whatever that case may be. And so I think determining what the risk is, are you in a place where there are no emergency or very limited emergency services? Are you in a place where internet potentially could go in and out, or that maybe they don't have like alarm services in your part of the state? And I think those are specific decisions to make for each employer. But I do think personally, and again, also working with businesses for over a decade now, that it makes sense to have those sort of anti-violence. And also so everyone's on the same page, like what is acceptable, what's not acceptable. Does the manager have access to a firearm on site versus everyone in the grow in the store. I think those are the things you want to clue in on of what makes the most sense for your business. And those things are all legal. You can limit firearms on your facility premises.
And also, some states, they do require you to have armed security guards, or some states, they might say you're not allowed to have armed security guards, but you can have a security guard that's not armed.
Right.
In some states, it's not required at all.
Yeah, yeah. Or even address, which we don't address it here.
Yeah.
I mean, one important distinction to make too, because we get this confusion. When we talk about infringing on someone's Second Amendment rights, that's the government infringing on Second Amendment rights. A private property owner can absolutely ban guns from being on their property, and they would not be at risk of violating someone's Second Amendment right. I want to make that very clear, because I think sometimes people confuse that. Oh, that's my First Amendment right to free speech. You don't have a right to free speech everywhere. The government can't prohibit your free speech, but an employer could limit your free speech.
I think you see it everywhere, actually.
The MED limits your free. You can't just advertise any way you want. There's regulations on what you can say about your business and where you can say it. So that being said, as an operator, you definitely have the authority to make that call. And in both directions, if you want to have your people armed in your shop, that's a discussion you need to have with your people. You can't force them to be armed, but you can certainly make clear it is our policy that we allow firearms. And if we do allow firearms, and this is where I think it is important to have a policy, that we know about it, that it's not in the work area or in your workstation, that it's secured in a certain area, just making sure for safety and dangerousness purposes.
That's really fascinating. Do you know anything about insurance and having a gun and cannabis?
Quite frankly, no.
I was curious about it.
I'll give you the lawyer answer, which is look at your policy. You gotta look at the language of the written policy. And we already know when it comes to marijuana insurance policies that there are a ton of exclusion. So making sure you're very clear on what is excluded from potential to make a claim is super important when you're shopping for your insurance.
I think that's all really helpful. I'm learning a lot today, and I have been in dispensaries where I've seen people have their gun right on their belt walking around. And if you think about it, it's just not federal buildings. When I've traveled to other cities, other states, you'll see decal stickers that has a no gun. Even when you go to national parks, you'll see no marijuana, no alcohol, no guns. You'll see all that information, and you just have to really pay attention. If you go into Target now, they even have little decals on the door that you can't walk into Target with a gun. Also, I've been in 𝗘𝗍𝗂, Colorado, for anyone knows where 𝗘𝗍𝗂 is. And there's all kinds of people walking around with guns on their belts in certain parts of Colorado where it's legal to have your open carry. I'm not familiar with all the language. I know there's concealing open.
One thing to think about is way back when, in 2013, the Deputy Attorney General under Obama James Cole came out with the Cole Memo. And I know you know about that, but it has since been rescinded by Jeff Sessions during Trump's first administration. But in that memo, and this was, again, way back in the beginning, and this was issued to provide guidance to federal prosecutors about marijuana enforcement. And they basically said, listen, you won't be high up on our prosecution list. We're not saying we're not going to prosecute you, but you won't be high up on our list so long as the states that have enacted laws related to marijuana have addressed certain issues. And there were 8 main issues that the government was concerned about: preventing distribution to minors, preventing revenue from going to criminal enterprises, preventing diversion of marijuana from states where it's legal to states where it's not.
Yeah.
Preventing state-authorized marijuana activity from being used as a cover for trafficking of other illegal drugs or other illegal activity. Preventing violence and the use of firearms in the cultivation and distribution of marijuana. There's 3 more, and I'll talk about those in a second. But that was something that was on the federal government's mind when they said, this is what we're going to look into and not look into. Now, again, we haven't really seen the feds, at least in Colorado, go after licensed, law-abiding marijuana business operators so long as On the beginning, they certainly did. I'm not going to say they didn't, as far as like where they were located, if they were too close to a school or, or if there was other concerns. But we don't really see that as much anymore. It's usually related to some of those other concerns that they had, right?
Yeah.
Like cartel activity, illegal activity, non-licensed activity.
Yes.
Just to let you know, like, this is where this has come from. This is where the ATF form came from, right? So that was one of the concerns, was preventing violence and the use of firearms in the cultivation and distribution of marijuana. And again, that we really haven't addressed that here in Colorado. Preventing drug driving and other adverse public health consequences related to marijuana use, prevent growing on public lands and dealing with environmental dangers posed by that on public lands, and then preventing possession or use on federal property, to your point about like the parks and stuff. Again, these were rescinded, but this gives you an idea of where we came from and where a lot of the states looked to when they were setting up their regulations, including Colorado, because we were writing our regulations at that exact moment when the Cole Memo came out. But there are always fact patterns that we have not dealt with. And we can't say that it's always, that this is absolutely a bright line rule. I will tell you, if you search the marijuana regulations for firearms, you're not going to come across that word in any of the regulations. Can local governments make further limitations? Yeah. So those of you who are listening who may be interested in getting into the marijuana industry as an operator, and as those of you who already are operators know, there's absolute major patchwork, city by city, county by county, state by state, on what the regulations are. And so knowing those inside and out are going to protect your business, your investment, your liberty. So making sure that you're very well aware, because certain local governments may limit further, whereas at least here in Colorado, the state doesn't limit that.
Yeah.
At least from a regulatory perspective.
Well, that's some good stuff. And wrapping up, do you have any best practices or tips? I know like Rachel cannot give legal advice, as either do I. Anything that we want to leave everyone with that just will be helpful?
Yeah, a few quick things. Number one, I'm just going to reiterate making a comment on that new ATF rule. We all know in the cannabis industry, we would not exist if it weren't for advocates and using your voice. And so this is a quick and easy thing you can do to let the federal government know that they need to back off on what their limitations are for marijuana, at least as it relates to gun rights while it is still federally illegal. If federal illegality goes away, might this go away? Yeah, it might. That's yet another reason to also call your federal representatives and keep hammering them on cannabis legalization at the federal level. There's bills floating around. There has been for the past 15 years, I want to say, in the federal government. Let's keep the pressure on. So that's one. Two, and this echoes what you said, have a policy. Whatever you do, just have a written policy, because if you don't, that's when things go left, right, upside down, right?
Yeah.
So having a policy, whether it's a facility policy or an employee handbook, of what's the expectation, so that way we're not caught off guard when an employee shows up with a gun and we don't know how to handle it. Right?
I agree.
So definitely that. Number three, keep an eye on what the Supreme Court's saying. Like I said, the case that is currently pending is called Hemani, U.S. v. Hemani, and the oral argument was last month in March. So that has the potential to really change what the analysis is for cannabis and firearms and what that intersection looks like. So those are my three things I would say. Keep an eye on Hemani, keep up the advocacy work, whether it's with your federal lawmakers or the ATF rules on this. We thought things were moving in the right direction for cannabis related to the DEA. Things really stalled out there, and there seems to be other fish to fry, I will say. Not bigger fish to fry, but other fish to fry, that we're not really seeing movement on that. And so I wouldn't rely upon any changes related to marijuana legality treatment at the federal level. Yeah, rescheduling. Yeah, like I have no faith that's going to happen anytime soon. We're definitely going to get a Hemani answer, though, before that.
I think eventually something is going to change with rescheduling in the future. I believe with all my heart it's going to change. I'm just not sure we're going to see anything here in the next year or so. It's up in the air, but I do have hope for the future, so I am a big believer in it. That's all really good stuff. Thank you so much. Such great information. There's no way I could have done that and talked about that on the solo episode. So I'm so glad that you came on and you did all the talking. So that was great. And that was very helpful. I will have Rachel's information in the description box along with the link that she's been mentioning if you want to contribute and participate in that public comment. And for those who like to stream the podcast, it is available on Apple and Spotify and wherever you like to listen. Also, please subscribe to my YouTube channel, which is at Under the Microscope with Jenny, and you'll be able to watch all the podcast videos on the channel. And once again, thank you, Rachel. And if people want to check out your website, what's your website?
Yeah, rzalegal.com. Still spending most of my time working with independent marijuana businesses in Colorado, figure out issues, open their new stores, close stores, sell stores, grows, all of those things, licensing, all of that fun stuff.
Colorado, New Jersey, and
Colorado,
Florida.
yeah, Colorado, New Jersey, and Florida.
Okay, I
So
just want to name
yeah,
some other states that you're in too.
yeah. We love working with, like I said, independent businesses with any issues related to real estate, licensing. We always send compliance things to Jenny, but God forbid, administrative defense. If you're getting an order to show cause, we work on those too. So I'm happy to be representing and in the corner of the small businesses who are leading the charge in changing the stigma against cannabis.
I love it. Thank you so much for being here. This was such a fun and interesting topic. Thanks for the suggestion. This was great. And thank you, everyone, for following along and coming on this journey every week with Under the Microscope. And we'll see everyone next week on the podcast.